Chapter 12. Mediation Mechanics. Outside sources are underlined in blue text. Forms available in our Forms package are underlined in red text. Links to each are below this video. We've introduced you to the mediation process. Now, we will take you through its doors. What does it look like? How can you best achieve settlement? What are some creative settlement packages? Chock full of tools and tips, this chapter will give you the best chance for mediation success. Your mediation, keys to success. With some wise planning, you can achieve optimum results at your mediation. Here are the primary keys to your success. Hold the mediation early on before emotions and attorney fees escalate. Choose the right mediator, an experienced professional qualified to serve as a mediator and skilled in the area of law of your dispute. Make litigation the adversary. You and your opponent will invest significant time, energy, emotion, and money when your dispute is decided by a judge, jury, or arbitrator. Act with a conciliatory state of mind. As parties who agreed to mediate, you and your opponent should have a new, conciliatory attitude. Your main goal now is to get past your dispute and move on. If you follow these steps, your chances of walking out of mediation with a signed settlement agreement are high. Representation. Must you have a lawyer? No. The mediator, by definition, is an informed go-between whose objective is to guide you and your foe to settlement. Many people do hire counsel, but it is not required and sometimes is just not warranted. Consider self-representation by all parties so everyone can be on equal footing, and document this agreement in a self-representation agreement. With mediation, you will be getting an attorney or judge with vast experience in your type of dispute. Why not let that person facilitate your settlement instead of each having an attorney to add complexity and expense to the proceedings? Remember, there is a cloak of confidentiality around the mediation proceeding, so anything you say cannot be held against you or even mentioned later. If you've already hired an attorney and the adversarial process has begun, it is a good idea to include your attorney. Just tell your attorney of your decision to mediate. If your lawyer balks, you're the boss. Suppose your attorney feels mediation is a waste of time? You can insist on it. You hired your attorney. You're the boss. Tell your attorney the truth. Before you commit yourself to the expense and rigors of arbitration or court litigation, you want to exhaust all settlement options. This includes mediation. Some attorneys will respond negatively for a multitude of reasons. Some will view settlement procedures as a threat to fees they may earn. To them, your interests don't come first. But you will find that many attorneys will agree it is best to attempt a solution early on. The endorsement of mediation by the courts is a powerful factor in the changing attitude of attorneys. If you decide to attend without an attorney and your adversary is represented, make sure you understand and can state the legal and factual issues of your case. Yes, the mediator you choose will have a background in the relevant area of law. But do your best to be informed. Although mediation is a settlement process, each party needs to understand their position, legally as well as factually, and be aware of possible outcomes. Why? Because meaningful solution comes from negotiations, and negotiations need persuasive elements, such as legal position and facts of the case. Working your way through Lawsuit Analyzer Copyright should provide you with a good basis for the research you need to undertake and the strong and weak points of your case. If you don't have a good grasp on your legal position, it may be a good idea to hire an attorney to appear with you, or at least to prime you in the legal issues. Smart cookie tip. If you want to share the law job, have the attorney prepare your mediation statement, addressed below, which is provided to the mediator and opposing parties in advance of the mediation session, and represent yourself at the hearing. Your mediation statement can be your guide to handling your case and responding to the mediator's questions. Mediation isn't the place to make your case. It's a place to intelligently respond to the merits and weaknesses of your case and do your darned best to agree to a settlement fully recognizing the battleground that lies ahead. Mediation providers. Review the document that contains the agreement to mediate. If it specifies a certain mediation provider, send the agreement to the mediation firm specified along with the provider's demand for mediation, found on their website. Many agreements state that mediation is to be conducted under the rules of the American Arbitration Association, AAA. With this provision, you have chosen AAA as your mediator. The parties can always select another mediation provider if all parties agree. If not, the forum is the one designated in the written agreement. If your contract does not specify the agency to preside over the mediation, you and your disputant are free to elect any mediation agency you choose. If you cannot agree on a provider, select some neutral way to have the selection made. Some clients toss a coin. Others agree upon a large mediation firm but cannot agree on which mediator. They then ask the impartial administrator at the mediation agency to choose for them. A ranking system, where you and your foe rank your choices among several mediators, is also an option. You might want to browse the website of the American Arbitration Association, AAA, which also handles mediation although it is not apparent in their name. They have many different panels of mediators, each carefully selected for their expertise with certain types of disputes. You may also want to contact Judicial Arbitration and Mediation Services, JAMS, which offers retired judges to preside over your dispute. There are many other mediation providers, and each has a plethora of information online. Selecting the right mediator. Your mediation's success or failure depends on your choice of mediator and the attitude of the parties. Willing participants are essential to successful mediation. Yet without the skill and training of the mediator, emotionally charged parties cannot bring about their own settlement. This is why you're here. You need every bit of skill and experience your mediator can offer. If you follow these recommendations, you will be assured of your best chance for a settlement. Select a mediator with formal mediator psychological training and who conducts many mediations. Your ideal mediator has the following attributes. Formal mediation training, including facilitation, negotiation, and psychology techniques. Extensive mediation experience and several good reviews. Broad knowledge of the subject matter of your dispute. A good settlement track record. Legal therapist. Experience with angry disputants and assisting in the release of such emotions. A good reframer with experience in altering the attitudes of participants. A good scribe offering on-the-spot generation of settlement agreements to be signed then and there. Background and training. You want to select a mediator with formal mediation training, who conducts many mediations and has a broad knowledge of the subject matter of your case. Go to the website for your mediation provider and search for the individual with the qualifications that fit your dispute. Most folks these days make important choices like this by reading reviews. The large mediation providers have lengthy profiles for their mediators, but no reviews. Take the biographical information for the mediator you are considering and search for reviews for that panelist via Google or whichever review database you use. Read them all until you get a feel that this person is right to facilitate the settlement of your dispute. Because most mediators are practicing attorneys or retired judges, you want to know that this mediator has successfully handled cases like yours. Then, go back to the mediation provider and ask if they can perform an in-depth search on the mediator of your choice as to the number of cases they have mediated, how many of those resulted in settlement, and a summary of their experience with the topic of your dispute. Some retired judges who provide alternative dispute resolution services are particularly well suited to mediation. But many are not. Although judges make excellent arbitrators because of their judicial experience, they sometimes make less than effective mediators. They are familiar with courtroom battles and are unaccustomed to a conciliatory atmosphere. The result of the mediation depends largely upon the competence and expertise of your mediator. If the above steps are taken, you will find a skilled and highly competent mediator to facilitate the resolution of your dispute. The mediator's expertise. Mediators typically charge a high hourly rate, but the reality check they provide is invaluable. The mediator can share war stories about what lies ahead if settlement is not achieved, often the perfect motivation for wrapping up a settlement package. Your mediator expertise includes: your mediator is an attorney or retired judge who has handled a multitude of cases similar to yours. Your mediator can recite the price tag and time it takes to get through the forum that will decide your dispute if mediation fails. You'll learn the probable outcome of your case, so helpful if your case does not resolve. When you're in the middle of your dispute, you think there's never been one like this before. The fact is your case is nothing special to anyone but you. In the eyes of the judge, jury, mediator, or arbitrator, they all come down to a simple set of facts. The mediator's many roles. Most well-trained mediators are masters of psychological techniques and intervention. They can orchestrate a full range of settlement postures. These traits qualify the mediator for her most important job: to whittle away the settlement gap between the parties. The roles played by a good mediator range from legal therapist to settlement navigator to jurisprudence scholar, reframer, and legal secretary. If the mediation is successful, as it is 85% of the time, your dispute is concluded. For this reason, most feel the mediator is as valuable as gold. In one day, a mediator can turn a bloody and expensive battle into a one-page settlement agreement. The mediation hearing. This video at Chapter 3 has a 7-minute video about mediation. Click on the 3 horizontal lines in the upper right of the video for a playlist to access just the information you're after. While this information is provided by the California Small Claims Court, it fairly represents the mediation process in all states. Perform an internet YouTube search and review a few more videos. Remember to customize your mediation. As is more fully described in the ADR chapter, be sure to customize your mediation proceedings to conform to the needs of the participants in advance of the session. This important step is not to be missed. If you skipped this step, ask the mediator to address your customization desires. Your mediation can be in person, online, or a hybrid process. The previous ADR chapter describes online mediation in detail with a list of its advantages and disadvantages as compared with in-person mediation. Regardless of which platform you choose, the process is the same. Submission of a mediation statement. Whether your mediator asks for a mediation statement or not, it is best practice to submit one. This document sets the tone for the mediation to follow, educates the mediator about your case, and establishes your credibility in the eyes of the mediator. The content of the mediation statement is: 1. Describe the underlying dispute. 2. Succinctly describe the issues in dispute. 3. Identify supporting legal authority for your side of the case. 4. Set forth the current settlement status. A well-drafted statement becomes a roadmap for the mediator in navigating the mediation process. Don't make it too long. If you haven't run your dispute through the Lawsuit Analyzer copyright, do so now. It will bring you to the frame of mind to begin your mediation statement. For their hourly rate, many attorneys will sit down with clients who are pursuing mediation and step through the facts, law, strong points, and weak points. You can have also them prepare your mediation statement for you. Having this document in hand, prepared with the help of counsel, can give you the knowledge and confidence to represent yourself capably. Introductions. Mediation typically begins with all participants in one room or online. The mediator first makes introductions and reviews procedure. Mediation proceedings are confidential. Admissions made are not admissible later in court or arbitration. The parties are asked to sign a confidentiality agreement promising to hold discussions confidential if they have not already done so. They are also advised that, under evidentiary procedures governing the mediation, the parties may also not later disclose facts or documents submitted by another party at the hearing. The submitting party can present its own evidence again later, in small claims court, arbitration, or trial, if those procedures become necessary. This initial sequence reinforces the session as one of conciliation, encouraging open communication and confidentiality. Joint open discussion. The mediator has each party's mediation statement, and unless a party has asked theirs to be held confidential, the parties have exchanged their statements with one another. The parties are invited to orally share their statements if they desire. The claimant, plaintiff, will usually go first, and the respondent, defendant, follows. Some mediators, depending upon their training, recite both sides back to the parties in a joint statement. This process is called mirroring. Although it sounds redundant, it is an excellent communication tool. It serves a dual purpose as you hear a third party objectively describe the case, and you can check that description for accuracy. You may hear your story in a whole different way, including its flaws. This initial joint session is vital for the following reasons. Each party is encouraged to focus on the other's point of view. Each party has an opportunity to air its own position. If mirroring is used, the dispute can be heard more objectively. The mediator identifies the key issues of the dispute. Some parties may choose to waive oral statements, feeling they adequately expressed their position in their written statement. The joint open session draws to a close after case descriptions, at which time the mediator begins separate caucusing sessions. This introductory phase is usually the only time the mediation is held in a joint session, until its conclusion. Separate caucusing. In a typical sequence, the caucusing process now begins. Its goal is negotiation. The mediator meets privately and separately with participants in person or online, depending on your platform. In this very interesting behavioral process, he or she groups and regroups most advantageously as situations realign. Caucusing may begin with the complaining party, with or without an attorney, or with one of the responding parties. In separate caucuses, the mediator discusses issues that may be barriers to settlement. Selection of the first caucusing party is the mediator's choice, depending upon the circumstances. For best in-person caucusing, the mediator may require the use of several rooms to separately caucus with each party and provide a separate private room for a party to evaluate settlement when the mediator moves on to negotiate with another party. The online mediation platform is set up to assign private virtual rooms. In these separate caucuses, the mediator discusses issues that may be barriers to settlement, shares war stories regarding possible results in later arbitration or litigation, and elicits settlement offers and demands. In a true go-between, the mediator shuttles back and forth making offers, advocating positions, registering demands, and answering questions. Information you provide may or may not be shared with other parties, depending upon your instruction. If you want something kept confidential, let the mediator know. He or she will follow your instruction. Negotiation sessions. The process continues until an agreement is reached, or until the mediator decides that negotiations have gone full circle and there is no agreement. If the gap is closed, the mediator brings the parties together and advises that a settlement is reached, reciting the settlement terms. If the mediator determines there will be no settlement, the parties reconvene and are advised that negotiations have reached a natural conclusion without settlement. The mediation hearing is concluded. Your mediation settlement. After a session climaxing with a settlement, the parties need written confirmation of exactly what they agreed to. The mediator then hopefully performs the role of scribe and prepares the parties' agreement in a written document signed by all. Online platforms typically include this service, but not all in-person mediators do. Ask in advance if your mediator does. If not, you must ensure that someone will be able to perform this important task on the spot. Smart cookie tip. Bring your typing fingers, computer, and printer just in case you are the one. And don't forget our form settlement agreement. Most settlement agreements arising from mediations are enforceable in court. This means that such an agreement is truly an end to your dispute. If a party reneges on the agreement, you can take it to court for enforcement. Some creative mediation settlements. In mediation, you can get very creative. Money is not the only form of compensation. Although money is the traditional way of compensating people for a legal wrong, mediation is not traditional. It's the cutting edge. As such, mediation invites new methods of addressing legal problems, and new solutions generate new bargaining chips. Tailor a settlement package with non-cash assets that work for your opponent by finding out what she wants. The parties are willing to mediate because they want to avert litigation. Outside the rushed court system, mediation focuses time and attention on creative means to settlement. There is no limit to the solutions available in a mediation with a creative facilitator and willing parties. For example, a settlement may involve cash, barter of services, materials, or an agreement to refrain from doing something. Below are some creative mediated settlements that illustrate one of mediation's finest achievements: creative thinking. The case of the guilty partner. Consider a mediation that arose from a limited partnership gone bad. The limited partners had a good case for fraud by the general partners. The claimant's potential recovery was more than $235,000. During their second separate caucus, it was discovered that the claimant investors were willing to settle for a package deal. The package consisted of several non-cash demands. An admission to the limited partners that several statements made were incorrect. Withdrawal of the partners from the partnership. An agreement not to compete in a similar transaction for 5 years, backed by a $300,000 pledge if they did breach. Amendment of tax returns to transfer tax benefits to the limited partners. Because mediation proceedings are confidential and inadmissible in any later dispute between the parties, a party can feel free to make admissions as part of the settlement process. If settlement does not come about and the dispute later goes to trial or arbitration, any such admissions are inadmissible for any purpose. They are completely veiled from disclosure. Thus, a mediator skilled in fashioning creative settlements was the key to the resolution of this dispute. The parties signed a settlement agreement containing the terms described. Following the mediation, a more detailed long-form agreement was prepared based on the terms agreed to at the mediation. Instant gratification cuts the bill in half. In many purchases, a cash offer up front can yield a good discount. The same applies to mediation. Each participant is at a different crossroads. One party's most important need may be immediate cash. This party may be willing to compromise as much as 60% for an all-cash settlement now. In this mediation, a structured settlement was fashioned, significantly decreasing the amount if payment was made in a shorter window of time. This was the perfect inducement for the responding party to come up with cash she just couldn't find before. The great "what do you need" compromise. Incredible as it may seem, some creative mediators explore solutions that have nothing at all to do with the underlying dispute. The job at hand is to determine what the frustrated party needs that the responding party might have. It's purely an application of the law of supply and demand. A mediator's skillful application of supply and demand can make a settlement successful. In one mediation, the dispute between the parties related to misrepresentation in the sale of a vacant lot where the buyer was seeking $35,000 in damages. The seller wasn't about to pay, although it seemed she had defrauded the buyer. The mediator asked the defrauded buyer if there was something other than cash the seller could provide. The buyer, recognizing that the seller had vendor connections that the buyer needed, advised that he would accept a certain product at a price that the seller might be able to negotiate with her vendor contacts. The mediation was recessed for a week to allow the settlement under consideration to be explored. A week later, the mediation reconvened. The seller was able to negotiate the price her buyer needed, the parties signed a settlement agreement, and the case, which was then pending in the upper civil courts, was dismissed. Smart cookie tip. Always remember, there are as many ways to fund a settlement as there are needs a complaining party has. Explore the claimant's wish list. The case of the glued gas lines. In one mediation, everyone, including the guilty contractor, agreed the work he did was hazardous, defective, and in violation of the building and plumbing codes. The most flagrant violation occurred when the contractor punctured the gas pipes he installed, and instead of replacing them, he made it worse by applying epoxy and tape to the pipes. Everyone, including the claimant and the guilty contractor, agreed that his shoddy workmanship and his reckless disregard of building codes caused serious damage to the claimant's property. Just based on out-of-pocket reconstruction costs, the owner's actual damage exceeded $45,000. Nonetheless, at their mediation, the claimant owner let the contractor out of the case for only $12,000. Why? At mediation, a lot of realistic thinking comes into play. Instead of focusing on the substantial award the owner could receive from the contractor at trial, the principal issue was how much the owner would collect from the contractor. If you win in court, will you be able to collect? Your court judgment is nothing more than a piece of paper unless the loser has the means to pay it. No one doubted that the owner would receive a judgment at trial. But could the owner collect on the judgment? The contractor claimed imminent bankruptcy. He produced several other judgments against him and a stack of outstanding bills. Sure, the owner would most likely receive a judgment, but she would have to pay more attorney fees to obtain the judgment. In a separate caucus with the owner and her attorney, it was estimated that it may take another $16,000 of attorney fees and costs to get to trial and obtain a judgment. Given the probability that the owner will never collect a cent on her judgment from the contractor, the owner quite realistically considered saving the $16,000 in future attorney fees. There is no limit to the solutions available in a mediation with a creative facilitator and willing parties. The mediation recessed for 3 weeks to allow the claimant time to think through a settlement package that might work for her and for the contractor to scrape $12,000 together. During that time, the complaining party hired an investigator to confirm the judgment-proof claims of the contractor. She also met with her accountant to consider any tax advantage from this situation. This responsible woman also wanted to ensure that the contractor would not do the same thing to another innocent homeowner, so she contacted his licensing board and tailored a license rehabilitation agreement with them. When they reconvened 3 weeks later, the owner dismissed her case against the contractor in return for the $12,000 payment. As part of the settlement, the contractor also agreed to give up his contractor's license for 6 months, complete a course of study focusing on safety in the contracting trade, and submit to a re-examination by the licensing board. The contractor's licensing board was set up to oversee this process. Use your negotiating skills to remedy the woes of the claimant. This mediation took only 10 hours in all to complete, instead of a lengthy, expense-ridden road to trial. The mediator's skillful application of supply and demand and the realistic projection of the owner's post-trial result made this settlement successful. Had the mediator not explored the contractor's financial ability, his inability to pay would not have become known. It was this very assessment that motivated the claimant owner to bring the attorney meter to a halt. Compared with her best possible result after a prolonged trial, the owner decided she was in pretty good shape, cutting her losses now. Smart cookie tip. Lawsuit Analyzer Copyright acts as your mediator in a way, making judgment collectability one of the factors in determining case feasibility. Real estate agents to the rescue. In another mediation, the real estate agents were able to use their talents to settle their matter. The buyer no longer wanted the property he bought. The seller failed to disclose material facts about the property, and the buyer threatened action against the seller and the real estate agents. The purchase agreement contained a mediation arbitration provision between the buyer and seller, and the real estate agents consented to mediation also. In this mediated settlement, the real estate agents did what they do best: sell, sell, sell. Although the agents believed they would not be found liable, they knew the realities of real estate litigation. They decided to do anything they could to keep this dispute from heading toward an expensive, adversarial arbitration. The real estate market was their place to make deals happen. The agents used their negotiating skills to remedy the buyer's woes. It doesn't matter what the need for each party is or who meets it. What matters is the need is identified and filled. The buyer agreed to list the property for sale with these agents, as long as the agents found a comparable property for the buyer to purchase. The mediation recessed with a written agreement stating these terms and retaining jurisdiction with the mediator in case issues arose during the settlement process. Because of their contacts in the real estate field, the agents were able to find a comparable property. They then listed the disputed property for sale with full disclosure of all material facts, finding a buyer in 2 months. The agents reduced their commissions on both transactions, but it was worth it. Settlement occurred and it was all over in 3.5 months. The seller ended up contributing very little to the settlement package, and the buyer was compensated by obtaining a new home at no additional cost. It took this mediator and these proactive and savvy agents 6 hours to put this settlement package together. The mediator's masterful facilitation and the real estate agent's realistic attitudes kept this case from running through an arbitration process that could have been quite cumbersome. Both real estate agents did well in the real estate business over the years. They prescribed to the principle that these situations were a cost of doing business. They were willing to do quickly whatever they could to end this dispute without paying hard cash. Through their services, they were able to meet the needs of the complaining party. It doesn't matter what the need is or who meets it. The need was identified and filled. What if you don't settle at mediation? If you know you have done all you can to avert disaster, your conscience is clear. Parties interviewed after unsuccessful mediations are nevertheless pleased that they pursued all possible settlement processes before moving on to battle. They realize that the next step, whether it be court litigation or arbitration, will be grueling and expensive. They feel that mediation was a wise detour before invoking warrior tactics. And what is their next step? The parties are invited to contact the mediator again if a position changes or the parties feel a continued session may be beneficial. If they have entered into an arbitration agreement, arbitration is next. Arbitration is approached after the mediator determines that settlement is not possible. If arbitration is not their next forum, arbitration is discussed with the parties who are encouraged to agree to arbitration. Often, although the mediating parties did not achieve a settlement, they decide against the court system and in favor of arbitration as their legal forum. This also makes them feel even more that the mediation session was well worth the time and expense. If they do not agree to arbitration, the House of Horrors will be their forum. There is no solution more satisfying and long-lasting than the one you achieve yourself. 85% of mediating parties emphatically agree. The other 15%, for whom settlement is elusive, would do well to choose arbitration as their next step. If they don't, they will have no choice but to spend years and hard-earned bucks traveling the court maze. Hopefully, arbitration is your choice.